Austin and Hunter were racist bullies. Tap, tap, tap. Okay, we're going to get there in just a minute. It's all right there. It's in their school records, so you McAlpians can go to hell. Yep, yep. Next, the appellate court filings indicate exactly what King Cass said about the Waller issue. Tap, tap, tap. Right? The failure to have a truly open court. That's what I said. And the Dream Team said it too. So there you go. You can keep going to hell. Also, we're going to show some of the criminal records and stuff at both the Metcalf residences. There's a whole lot of stuff going on there. And then there was another issue over here at Megan's house. I got back in 2008. Okay. And this is the letter that came out to me. And
what's going on, everybody? Welcome back to On Go, man. It's crazy, man. The Karmelo Anthony case has just took a major turn. A motion for a new trial has now been filed along with a request involving the judge's recusal. And we're going to read through the court paperwork together, and we'll break down what these filings actually say and explain what they could mean for the case moving forward. And to separate the filings from speculations and all of the other things and the misinformations that's happening online. You already know. I'm Uda. Welcome to On Go. Make sure that everybody's hitting the like button. Make sure everybody's hitting the polls. Make sure you are subscribing to On Go. Be a part of the Go gang today. You already know, here we On Go and we On Go together. It's not about us being individuals. When we're individuals, this is how things happen to us. We have to stay together. This is how it goes, man. Weak people get around strong people. Less confident people get around confident people. Shy people get around people that's confident. People that's not leaders get around leaders. And this is how we get steel to sharpen steel. All right. That's what we're doing here on Go. So we're going to get into the motions for a new trial. I read some of the documents yesterday, so I will be continuing from where I left off. I'll just move up a page or so that we can all see the documents. But we will be getting back to the Metcalf brothers being bullies. Some people say they weren't and they couldn't be. Yeah, all right. Yeah, all right, bro. We're going to get to that. So don't worry about that. So salute to everybody. Make sure y'all all are slapping the like button and make sure you all are notified when we drop new content, right? Let's get right to it. All right. Tierra Allen flew in from Arizona and observed the jury selection from an auxiliary viewing location she knew as the Oval Room on June 1st and June 3rd and on June 4th. And she was told that the accommodation had been eliminated and she was excluded from the courtroom on both June 4th and 5th. Let me just make it a little bit bigger if y'all want it, right? I'll make it a little bit. Y'all can see it though, good, right? Y'all can see it good? All right, cool. Y'all good. I'll zoom in if y'all need me to. Y'all just get in the comment section and let me know if y'all want me to zoom in, and I'll zoom in. June 4th and June 5th. Bridget Smith attended on June 1st, 4th, 5th, and 6th and confirmed that public seating was capped at roughly 27 seats. That admission was divided into two lines, one for the media list and one for everyone else, and that the outside viewing locations used during the jury selection was eliminated once testimony began. Tamitra Carter arrived before dawn and, though identified as number 7 on the early arrival list, was removed from the June 5th line and lost that morning's proceeding because only about 27 public seats were available. Kiara West, a member of the general public with no media affiliation, was denied entry on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. If you don't understand what that means, let me update you from where we left off. When you was going to the court, you only could be in business attire. You couldn't wear logos. You couldn't wear nothing expressive, nothing to say free Karmelo, no things like that. That's first of all, right? If you came at a certain time, before the times that the judge allotted you, even on the grass, okay, you would have been held in contempt of court. You'd have been removed from the grounds, even physically removed from the grounds. But what we discovered yesterday is that maybe Karmelo Anthony lawyers did set him up, man. I got to tell you this now, man, because they agreed to things from the very beginning. They agreed that they wouldn't call no psychologists. They agreed that they wouldn't call no character witnesses. They agreed to all of these things in motions from the beginning. They've agreed to these things. All of the agreements that they agreed to only benefited the prosecution. And that's the sad thing about this. Not only that, before he could waive his Fifth Amendment right? When you go to speak about it, if you want to testify or not, they only had 10 minutes to talk to their client, a 19-year-old, which is Karmelo Anthony, to make the biggest decision of his life, try to coach him through the biggest decision of his life. They tried to get more time, and even if they tried to get more time, no more time was allotted. Then he was the one that would have had to testify for his own defense. And he would have had to testify as one of the other witnesses under the tent. They only were focused on things that happened under the tent. Okay, you already know when an event, a tragic event like this happens, the prosecutors want to move from the event moving forward, everything that happened from the event and everything that happened after. But the defense's job is to take not only what happened at the event and forward, but the defense's job is to move from the event backwards, going into the history, what could have led up to these things. All of those things are for the defense to prove. And we can understand why the defense was doing such a that lackluster job that they was doing, because it was just shaky work, man. Honestly, it was just really, really shaky work, man. So we're going to get back into this read. Let me just zoom a little bit. You already know the vibes. All right, cool. Let's get back to this. But it looked like choo-choo. It's looking like a railroad, bro. I'm not even going to lie, man. You got 10 minutes to make the biggest decision of your life. You're live in court. The jury, your defense needs to come and talk to you and coach you through this. Yo, listen, man, look out for this question. Look out for this. Take your time. Listen, 10 minutes only. 10 minutes. Think about that, all right? Not only that, the removal of the oval rooms, the overflow rooms. The overflow rooms are used so that other people who don't make it into the main court can get inside the courtroom and listen to what's being said, all right? Not only that, the public, okay, the taxpayers of Texas, it is their right constitutionally to be able to be a part of that trial, to be able to look at the juries, watch over the jury and the judge, and make sure everybody's doing what they're supposed to do and to keep them honest. There was no audio feeds. There was no live feeds. There was no live streams. There was no video feeds. Then there was only 9 legacy media that was allowed into the trial, into the case, right? So now you already know the news will tell you whatever they want to tell you. That's the good thing. Sometimes it's a good and a bad thing that we have people like me that is not like legacy media, but I'm covering cases, covering trials, covering news stories, because I'm going to speak from my lens. I was at the Diddy trial. You know how many people came to me, yo, Uda, man? News people, yo, man, I wish we could do what you're doing, man, because the news channels, they stifle us. They don't let us report what we want to report. They don't let us do videos on what we want to do. So they don't have free reign to say what I think about a case. I can say, yo, man, I think this. They're never going to go off the cuff. They're always going to color within the lines. Okay. So shout out to Nika Knight. Shout out to Queen Sheba. Shout out to my sister that was out there in real time and getting this work for us. All right. Cool. All right. On the early arrival list on June 5th, let's get that. Tamitra Carter arrived before dawn, and though identified as number 7 on the early arrival list, was removed from the June 5th line and lost the morning proceedings because only about 27 public seats were available. Kiara West, a member of the general public with no media affiliation, was denied entry on June 1st on a purported jury members only rule and was physically removed from the courthouse on June 6th because of the expressive content of her clothing. And Tony Toussaint, the defendant's own grandmother, attests that the family access was capped at 8 seats in total. They were supposed to have 15 seats for Karmelo Anthony's family, 15 seats towards the Metcalf family, but it was capped to 8 seats in total, and his own family wasn't even making it in the trial. And these are some of the reasons why his defense is seeking a new trial. Because in one case called Stricker, in the Stricker case, a person came to the court and wasn't allowed inside the court, and they was guaranteed a new court case just based on new trial, just based on the one person, and that person wasn't even a family member. But this person has family members that's supposed to be there, and they weren't even allowed inside the courtroom. Okay, cool. The defendant's own grandmother attests the family access was capped at 8 seats, so the defendant's grandfather and aunts were excluded from his trial altogether. And that even those admitted were required to register a day in advance and were warned that a visible facial expression, you hear me, Just looking, you could have had an itch. Hopefully you ain't itching in your lower regions, but you could have had an itch. If you itched, they would have switched. And they'd have Jazzy Jeffed you out that courtroom. Do you hear what I'm saying to you? On Jesus' sandals, I ain't never lied. Look, it could result in removal. One of the members of the public attended the trial nearly in its entirety and provides a day-by-day account that corroborates each of these features from inside. Nakia Washington traveled from Cincinnati, Ohio, and was present at the courthouse on June 1, 3, 4, 5, 6, 8, and 9, which was the sentencing day and the day of the verdict, 2026. During the jury selection, the court used an auxiliary viewing room known as the memorial room. That's one of the overflow type rooms, okay, where other people, public, and not only just the public is in these rooms. You got lawyers, you got press, you got news people, because not everybody makes it on time to be inside the main courtroom, just like Diddy's trial. So you'll go to the overflow rooms. But one thing about Diddy's trial is that they had multiple overflow rooms. Even when Kanye came that day, they opened up a whole nother courtroom so that Kanye wouldn't have to be around the public and people like us and everybody. And he went into his own room and was able to watch the proceedings and listen to the proceedings for himself. Okay. They made arrangements and accommodated not only the public, but everybody that came to his trial, Diddy's trial. Okay, cool. The memorial room that seated roughly 60 members of the public and carried a live video and audio feed of the proceedings. On June 4th, the first day of the testimony, the public was informed that only after arriving that the overflow room would not be available for the remainder of the trial, and access was thereafter confined to approximately 27 seats inside the courtroom with no overflow rooms, no audio feed, no video feed of any kind. Access each day was governed not by the order's admission time, but by a pre-dawn line that formed as early as 4 to 4:30 a.m., was counted off in groups of 27, and was inconsistent and at times chaotic. And although Ms. Washington ultimately gained entry on each day she attended, she was excluded from morning proceedings on both June 4th and June 5th, admitted only in the early afternoon after substantial portions of the day had already passed, so that even an attending member of the public was denied access to significant parts of the trial. She observed no disturbance or disruptive conduct inside the courthouse that would justify excluding the public. The only altercation she witnessed occurred outside in the line and arose from the very manner in which the court administered access. This case is not controlled by the decisions on which the states may rely. Dixon versus State. The Court of the Criminal Appeals held that a public trial right is forfeitable and that a full courtroom standing alone does not violate the guarantee because the right does not require the court to seat every person who wishes to attend. The defendant does not contend otherwise. The violation here is not that the courtroom filled. The violation here is not that the courtroom filled it. It is that the court adopted in advance and without case-specific findings a reoccurring access regime that limited the general public to a 10-minute daily entry window and roughly 24 seats, barred meaningful mid-proceedings access, and furnished no contemporaneous alternatives for those foreseeable excluded. Nor would Dixon's disposition aid the state there. The claimed exclusions was a portion of a single day's closing arguments, proved by one witness against an otherwise silent record. And the trial court resolved the resulting factual dispute only after a contested hearing. Here, the closure spans the testimonial phases of the trial and is established by 7 mutually corroborating sworn accounts, by the written admission of the court's own appointed officer that there is no overflow room, by the court's own televised confirmation of the seating figures, and by the undisputed elimination of the accommodation the court had itself been providing, and no findings of any kind exist to which deference could attach. Nor is this William versus the state, in which The Court of Criminal Appeals treated the brief exclusion of a single family member during one witness's testimony, mitigated by a live video feed to a neighboring courtroom, as trivial, right? De minimis closure that did not implicate the Sixth Amendment. The restriction here was the opposite of trivial. It was not a single brief exclusion tied to one witness. It was not accompanied by any live feed, and it was not supported by witness-specific findings. It was a trial-wide access regime applied across jury selection, the guilt-innocence phase, and the punishment phase under Williams' own framework. A closure of that scope is tested under Waller, not excused as de minimis. Indeed, the Williams court took pains to cabin its holdings. It characterized the trivialities doctrine as an exceedingly narrow exception, reaffirmed that Waller remains the primary framework for analyzing courtroom closures under the Sixth Amendment, and admonished that the doctrine should be employed sparingly only in the narrowest of circumstances. The court expressly declined to mark the doctrine's outer boundaries, leaving that task to future cases with different facts. A standing trial-wide access regime spanning jury selection, the guilt-innocence phase, and the punishment phase is not the rare circumstance William contemplated. It is the ordinary closure for which Waller supplies the governing test, and this Court of Appeals has already applied that the principle to reject the very trivialities, arguments, and the state may advance here. In Stricker is the case that the one family member, I think, didn't get in. It declined to treat the exclusion of a public from the jury selection as trivial, holding that the values sought to be implicated by the Sixth Amendment are violated when the public is excluded from jury selection. The defendant need not prove that every seat was empty or that every member of the public was excluded. At minimum, the access regime was a partial closure. Members of the public were repeatedly excluded from substantial portions of the proceedings, while no continuing overflow, audio, or video access was provided. Under Williams and Stricker, even a partial closure must satisfy the remaining Waller factors. Okay, I do want to pull up the Waller factors so that you can kind of know exactly where to go. Give me the 4 points of proving the Waller factors. Give me the 4 points so I can read to the people. Waller factors: narrow tailoring the consideration of the reasonable alternatives and adequate findings. Those factors are absent here. Hold up. Let me do this. Yeah. Okay. 1. These are the 4. 1. There must be an overriding interest that is likely to be harmed if the proceeding remains open. 2. The closure must be no broader than necessary to protect that interest. 3. The judge must consider reasonable alternatives to closing the courtroom. And 4. The judge must make specific findings on the record explaining why the closure was necessary, which he never did. There was no explanation for why the closures were even made at all, right? And even if you went through the electronic files trying to go and figure out if you could make a filing or make a complaint, there wasn't no feature there for you to even make that formal complaint, okay? So some of these Waller factors were broken, okay? Cool. Or not adhered to, at least, right? These decisions do not create a mechanical rule that a live feed is always required or always sufficient. They make a narrower point. When seating limits predictably exclude the public, the trial court must consider practical alternatives: reserved public seating, a larger courtroom, staggered admission, an overflow room, or an audio or a video feed, and must make findings explaining why any rejected alternative is inadequate here. The court used an overflow room alternative during jury selection and then withdrew it when testimony began. So They show you the Waller v. Georgia. Waller is the case that they keep citing. It's called Waller versus Georgia, U.S. 1984, the time it happened, right? No, the entire suppression hearing was closed with no alternative offered. The outcome, the closure was unjustified. New suppression hearing was ordered. Okay. Stedman, in the Stedman versus the state, right? No, it's an overflow room or live remote feed available. So that's the no that we're saying no to. Okay. Family barred from voir dire for lack of rooms or alternative not considered. The outcome, the structural error conviction reversed and a new trial was ordered. So some people saying that he doesn't have a lot of grounds for a new trial, but he actually does. He has a lot of grounds for a new trial. I just think that this case was shoddy from the very beginning. And I just believe that even his own defense agreed to things that they should have never agreed to. Even when the witnesses came on the stand, they had no pushback. All of these things were spoken about, that how the victim, they said that all of the witnesses came off the stand without contest. They didn't go into the alleged bullying that the twins were being and doing. They didn't go into the history of the twins, how they could blow up and how they could get aggravated at a time. All of these specific things, just like in the introduction of this video, it shows that it's going to the history and the patterns of both brothers, Austin and Hunter. RIP to Austin, you know what I'm saying? Straight, man. He's a kid. I don't think that he should be dead right now. And I don't think that Karmelo should be serving 35, but we just gotta call a spade a spade. I don't believe that that prosecution wanted to go into the past of those boys and the past of Karmelo, because you would have seen that his past was not speckled like those boys were. Sometimes we just see faces like this and you just presume that a person's a King Vaughn and a person's like that. Not everybody's like that. Doesn't matter what color you are, okay? Just remember what I'm telling you when it comes to that. All right, cool. Let's go down. Lilly versus the state. As far as the courtrooms and the live feeds and all of those things, no to all of those, right? No. So a trial conducted in a restricted access setting, some similar to Karmelo. Structural error, new trial. Presley versus Georgia in 2010, no to that answer as well. Reserve rows, overflow room wasn't even considered in that. What happened? Reversed. Trial court must consider reasonable alternatives, period. William versus State, yes. Live feed to a neighboring courtroom. But what happened? The outcome, a trivial closure, no violation. Zorns versus Bolin, yes. A remote viewing from an observation room. So they actually had an observation room in this case, like set up like an overflow type of room. Trivial closure with no violation. And this case, provide none. Provided only during jury selection, then withdrawn for the testimony, no fee thereafter. So what's the outcome? Falls on the Waller, Stedman, and Lilly side of the line. So they gave you cases that they actually had feeds or made some kind of accommodations to the public and to everyone else. And then they cited their first cases, which they're standing on and using for their own defense, which is Waller, Stedman, and Lilly, those three cases. Cool. This case sits on the wrong side of that line, and uniquely so. The court did not merely fail to provide an alternative, it provided one during jury selection. So you actually did it before, and then you pulled the rug. So it's not like you never did it, and then you said, you know what? We don't need to have an overflow room. We're just going to do it just like this from the very beginning, because this is how we're going to maintain privacy. And this is how we're going to maintain misinformation and all these different things with this trial. No, you actually provided one at first, and then you pulled it back with no response, no answers, or nothing to say to nobody. See what I'm saying? So that's the problem that Karmelo's defense team is having. During jury selection, a live feed to an overflow room and then switch it off for the testimonial phases. The most consequential part of the trial, a court that has shown it can pipe the proceedings to an overflow room and then darkens the feed when the witnesses take the stand, has not taken every reasonable measure to accommodate the public attendance. And as the public, our tax-paying dollars makes everything run. It is our constitutional right to be in the trial. It cannot stop us from being there. Okay, we are there as members of the public. This is how you make sure that people get fair trials. Remember, this is how it goes. Okay, so we can't be there. Why? Think about that. It had done actually the opposite. Critically, the closure was imposed by the court on its own motion. No party moved to close the courtroom or to restrict the public access. The court entered the amended order. They amended order, conducted to no evidentiary hearings, and received no evidence in support of any offered to justify the restrictions. Now, the defendant was not afforded a pre-ordered hearing or an opportunity to be heard before the access regime was imposed. And the written order did not disclose the facts that made the closure apparent in operation. The actual allocation of public and family seats, the defense family limitation, the withdrawal of the overflow room when testimony began, the denial of the alternate access, or the off-record administration of the public line. D, in actual operation, public access was even more restricted than the order's text provided. The deficiencies in the order's text were compounded by the way the access regime operated in practice. Because a closure is assessed only on the totality of the evidence, the actual operation of the regime is properly before the court. Cameron, they cite Lilly again. The affidavit of Thelma Anderson, a member of the public who repeatedly sought to attend the trial, establishes that the regime operated more restrictively than its text provided, and that reasonable alternative was not merely overlooked, but affirmatively withdrawn. These facts compound the deficiencies apparent in the order's face. They do not supplant them. Consistent with Cameron and Lilly, the closures is established on the totality of the evidence, and the defendant need not to show that any particular member of the public was excluded. Most significantly, the court demonstrated that an overflow viewing room was both available and workable, and then took it away. During jury selection on June 3rd, 2026, the court provided an auxiliary viewing room location outside the courtroom where members of the public who could not be seated inside could still observe the proceedings. The court did not merely provide this accommodation, it announced it in writing before trial. On May 29, 2026, the court appointed the public information officer, advised the public that the media and the general public will have an opportunity to watch a live feed of the jury selection process from the ceremonial courtroom with television monitors and audio provided, and that once testimony begins, the proceedings will take place in the 296th district courtroom following the same procedures. On June 4th, 2026, the first day of testimonies, the court eliminated that accommodation and confined public access to the seats inside the courtroom with no overflow room, no audio feed, and no video feed of any kind. The significance is twofold. First, the court's own use of an overflow room during voir dire proves that a reasonable and readily available alternative to the exclusion existed, because they did it at first and then they took it back. So it's not like they never did it. If they never did it, they'd still be beefing about it. But at least you could say you never did it because you would have thought that that was the right thing to do. But they took it and pulled it and gave no explanation. Okay. The very kind of alternative that Presley required the court to consider. Second, the court did not merely fail to consider that alternative, it adopted the alternative and then withdrew it for the guilt, innocent, and the punishment phases without findings and without explanation, narrowing public access precisely as the most consequential testimony began. Now, the reason a deputy gave members of the public for refusing overflow that the trial courtroom was the only room without video conferencing Zoom capability does not withstand scrutiny. The defendant expects to establish at the hearing through the courthouse administration and information technology witnesses that courthouse space and technologies were available to provide continued overflow or audio or video access. At minimum, the court's public statements thanking the other judgment. This is what the Judge Roach did. After he came out to speak about the trial, he was thanking the other judges, saying, you know, thank you for y'all time and y'all being so patient with us, because, you know, other judges have courts cases in the same building, right? But they provided no overflow room, right? They took the overflow rooms and all these different things. So he ended up saying, thank you for your patience, because, you know, when I pulled the overflow rooms, we didn't say nothing about it. We never gave an explanation, but everybody was working with them. So they thanked the other judges. Thanked Judge Roach, thanked the other judges. Okay, so that's what they're talking about here, right? The court's public statements thanking the other judges of the county and the county's information technology and facility departments for their flexibility in meeting the demands of this trial raise a fact issue that the court was required to explore before withdrawing overflow access. So that goes to show you that they didn't even tell them an explanation and then give no nothing. See what I'm saying? Cool. The court had moreover already deployed an overflow room with a live video and audio feed during voir dire, and establishing that the space, the equipment, and the personnel to provide it existed, and acknowledged that an audio stream of the proceeding was feasible. The order only affirmative public entry window, which was the 10 minutes between 8:50 a.m. and 9 a.m., proved illusory in operation. In practice, and limited public seats were claimed by a line began forming in the pre-dawn hours, often between 4 a.m. and 5 a.m. Admissions turned not on the entry time the order specified, but on how early a member of the public was willing to arrive and wait. A member of the public who appeared at 8:50 a.m., the time the order designates for public entry, had, as a practical matter, no realistic opportunity to be seated. The narrow window the order provided on paper was therefore narrower still in operations, even though you're saying it's a 10-minute window, even though you're there since 4 o'clock, but it's still no real guarantee that you're going to be in there. Some people was like 7th in the line. Next thing you know, when it's time to get in the court, you 35th in the line. So you ain't making it in there, because you know they're telling you it's about a couple of dozen or so seats. They saying at one point it was 27 so seats, right, for you to get up in there. So if you're 35th, you don't make it in. Okay, people cutting, skipping lines, all type of things going on. You know what I mean? It's real in the court. The admissions process that the order set in motion operated without transparency or consistency. The order prescribed no method for allocating its limited public seats. In practice, admissions was governed by an informal line in which some individuals were permitted to move ahead of others who had already been waiting for hours, just like I just told you. So that a member of the public who arrived early and secured a place near the front of the line could nonetheless be displaced to a position well beyond the number of available seats. And although the order barred re-entry once proceedings began and made no provision for admitting waiting members for the public as seats opened, seats did become available during the trial day as observers came and went. Yet members of the public who had waited outside were admitted, if at all, only hours later, after substantial portions of the proceedings had already passed. Nor does the order's provisions for admissions at a recess cure the exclusion. Admissions at recess after the morning's testimonies had been taken is exclusion from that testimony. And unlike the brief single witness exclusion in the Williams case, it was a brief single witness, just one witness was excluded. And that whole thing went to a new trial, right? Mitigated by contemporaneous live feed, the exclusions here were mitigated by no feed at all. Now, so if the Williams one had a live feed, then there was no violation. And they said, I'll go back up to the categories that they said, and we can see exactly what happened in the Williams case. The operation of the order thus preceded the precise harm its text foretold. Members of the public excluded from significant portions of the trial with no contemporaneous means of access. Now, finally, the mechanisms by which the court administered and defended these restrictions operated off the record. A member of the public's request for the alternative viewing location could not be filed through the county's electronic system. Remember what I told you? There was no way for you to say nothing about this. You couldn't even request it. You couldn't even say nothing about it, right? Through the electronic system for a criminal case, and was instead routed by email to a public information officer designated by the court, who reviewed and denied the request outside any judicial proceeding. No hearing was held, no evidence was taken, and no order subject to the appellate review was entered. At the same time, the member of the public who observed these proceedings describes no disturbance, security incident, or disruptive conduct by any member of the public that would explain the restrictions imposed. The as-applied operation of the order thus confirms both halves of the defect. The closure was more severe in practice than the order's text, and the generic speculative findings offered to justify it are contradicted by the conditions the public actually encountered. These conditions can be stated with precision because they recur across the sworn accounts of the members of the public who tried to attend, including the affidavit of Thelma Anderson and the accompanying declarations, and the court-appointed public information officer's own email. The amended order addressed entry times, a 9-person media cap, space available seating, and re-entry. It did not address and it did not authorize the following features of the closure that govern access to this trial in practice. A cap of roughly 27 seats for the general public, a number the order never stated. I'm gonna stop there for a second. Let me just check on the chat. Let me just check on how we doing. Cool. Salute to everybody that's in the building. Salute to Shadow. Salute to Queen Brielle. Salute to y'all. Hello, Moto. The Mike Howard statement, I know, right? Nasty work, bro. It's nasty, bro. It's nasty, bro. Shout out to my bro, Shadow. Yeah, shout out to Queen Brielle. Shout out to Hello Moto. All right. Let's get back to the findings. We got through A. B, an off-the-record allocation of the courtrooms, approximately 70 seats, 15 to each side's family, 9 to the media, and the balance to the court staff, leaving only about 24 seats for the general public. So remember, Karmelo supposed to have 15 seats for family members, yet it was they're limited to damn near 8 seats. Even his own grandfather and aunts ain't make it in the damn trial. Nasty work, bro. C, the provision of an auxiliary overflow room, viewing room, during the jury selection process on June 3rd, 2026, and its elimination on June 4th as testimony began, with no overflow room, audio feed, or video feed of any kind or thereafter. D, admissions governed not by the order's 8:50 a.m. entry window, but by a line that formed in the pre-dawn hours, you already know, between 4 and 5 a.m., so that the arrival time, rather than the order schedule, controlled who was admitted. The absence of any method for allocating these limited seats, producing an inconsistent and non-transparent line in which some persons were permitted to move ahead of others who had waited there for hours, displacing members of the public who had arrived early to positions well beyond available seats. F, the administration of public admission and the denial of access by a court-appointed public information officer and county staff who described the process in a collective first person's view. We chose, we invited, we had no choice. So you left it up to this guy to decide who the hell getting up in here and why people ain't getting up in here. Who you, homie? Who's you? Who you? Crazy, nasty work. Could have been just biased as hell. What type of thing is going on? They running some janky promotions, bro. Janky. A standardless media determination that permitted self-designated media to consume the public's limited seats. The routing of a request for alternative viewing location by email to the public information officer because the county's electronic filing system provided no category, and I was telling you, it provided no category for a criminal courtroom access request. So you can even ask for requests. Only 9 guaranteed seats, and those 9 guaranteed seats were to legacy media. Big news company, a channel down there in Texas down there, and some publications, maybe like a newspaper or two. they got a chance to be in the court every single day without harassment. And I mean, just straight through the court. And the denial of those requests outside any judicial proceedings, leaving no hearing, no evidence, and no order subject to review. An initial prohibition on bringing notepads or pens into the court. What? You can't bring no notepads or pens. What? Later modified. Okay, cool. Because that's crazy. How the hell are we supposed to write these things down? You think I could have remembered all that information when I was covering Diddy's trial? Bruh, you need to be able to write this down. I'm writing like this. Yo, I ain't write like that, bro. Bruh, since I was little, bruh, I must have been in fucking elementary school, bro. Shit, word, bro, like that. What Jane Doe said? What? Scandalous ass. Cassie, I don't play with Cassie. She was Diddy girl. But Jane Doe was a scuzz. I've been said in the court. I'm gonna do a video on Jane Doe. And people were trying to cook me at the trial talking about, oh, she a victim. Bruh, the woman haggled the price, only $10,000 to do all the things that she did, and she was dealing with a billionaire in Diddy. Do you hear me? She never even seen the $10,000 in her hand. She asked Diddy for $25,000. He said no. He asked her for 20. He said no. He asked her for 15. He said no. She asked her for 10. He said, all right, cool. This is after they was arguing. And this is the time when if you're a woman, you know you got a man. Y'all done went through an argument. You got him by the short and curlies. This your time to get what you want to get from this guy. She never even seen the money in her hand. You hear me? The money went from Diddy's account, and she took all the $10,000 to pay for a house for her to stay with her kid, right? And Diddy was doing FOs in her house. You hear me? She never saw the money, and all through the trial, Diddy was still paying the rent, the $10,000, and paying for her lawyer, Jane Doe, 50 baby mom. And you gonna tell me she not scandalous? Yeah, all right. Whatever. Anyway, the physical removal of turning away of individuals, members of the public, including the removal of a member of the public for the expressive content of her clothing, and the denial of restroom access to her minor son. You couldn't leave, bro. If you left, you was out the damn court, period. No re-entry. Cool, they was running a tight ship. A limit of 8 total seats for the defendant's own family, which excluded the defendant's own grandfather and aunts from his trial altogether. Partial access, even for those eventually admitted, who in some instances were seated only in mid-afternoon after a substantial portion of the day's proceedings had already passed. None of these conditions appeared in the amended order, and none rest on any findings that the court made or any evidence the court had received. Assessed on the totality of the evidence, they established that the proceedings was closed far more severely than the order's text discloses, and that the closure was neither narrowly tailored nor the product of the consideration of reasonable alternatives that the law requires. Now, the order fails the Waller test at every step. The first Waller factor was never satisfied. I just read you the 4 Waller factors, okay? They said the first one alone. I thought they brought maybe 1 or 2, 3. The first one out the gate, homie, already up. The first Waller factor was never satisfied by anyone. That factor requires the party seeking to close the hearing to advance an overriding interest that is likely to be prejudiced. Waller, 47 U.S. at 48 point. Put a dot there. Here, no party sought closure. No interest was advanced by any proponent. And because the court took no evidence, no interest was shown to be likely to be prejudiced. Right? Listen to that line again. Because the court took no evidence, then no interest was shown to be likely to be prejudiced. Did the judge and them do this purposely? I've been working on the railroad all my long days. We've been working on that railroad. It's a railroad, homie. Ted Bundy, Manson, everybody, Son of Sam, bruh. John Wayne Gacy, all serial, all of them peoples, bruh. They never went through none of this, bruh. This was a kid on kid crime, bruh. Young people, bruh. I don't think Austin really knew that if he put his hands on Karmelo like that he would have been unalive. God rest his soul. And I don't really believe that Karmelo really knew that, yo, listen, man, I'm about to poke him and I'm about to take his damn life and I'm about to be serving 35 years. If they both knew this would not have happened. But the first one justifies the second one. Because why are you over here pressing on people and putting your hands on people, bro? Why are you doing this? I'm not saying he's supposed to unalive him, but bro, what you doing to me, bro? And I'm giving you fair warnings. When we bring up the 911 call, when somebody over there said, yo, Austin made a move, yo. Why is Austin thinking that he's Clark Kent Christopher Reeves and he making a move on somebody that alleged to have a weapon? Why he had the weapon, we never gonna know because he never testified. But why do you feel the right to think that you, oh yeah, that you Macho Man Randy Savage, bro? Your mother never told you don't put your hands on people, no matter what they saying, unless it's really something that you really need to be doing. Just don't go running around just putting your hands on people. Your dad never told you that. Family members never told you, keep your hands to yourself. When you was fighting with your little cousins in them, when you was fighting with your little brother, your little sisters in them, they never told you keep your hands to yourself. I'm just saying, bro. I know I was told. You wasn't told? Yeah. Mm-mm-mm. Mm-mm-mm-mm. The court's generic recitals cannot supply that showing, and a court may not relieve itself of the burden by acting on its own motion. To the contrary, in Presley versus Georgia, the trial court excluded the public from voir dire on its own motion, and the Supreme Court reversed precisely because a trial court must satisfy Waller and must consider reasonable alternatives, even when the parties do not propose them. The remaining Waller factors fail as well. Damn, all the Waller factors. I thought probably like 3. Stevie can see the railroad. He hear it too, you know. Because when you can't see, you got your hearing is like supersonic. So he can hear the railroad. Choo choo. He hear the train coming. But Stevie Wonder could see this railroad. And y'all gonna bother me in my chat. You can say whatever you want to say on Go. Just let us be respectful in some ways, okay? And don't try to curse the host, okay? Have your own opinion. I let everybody have their own opinions because I don't believe in echo chambers. But Stevie Wonder, my Sherry Moore, I can see the railroad more and more. He can see the railroad more and more. Don't lie to me, bruh. Tupac told you in what, 99, 98, no, what, 89, what, yeah. You ain't got the lie to kick it. I think Pac said it. You ain't got the lie to kick it. You ain't got to lie, Craig. Friday. You ain't got to lie. Today, Wednesday. You ain't got to lie, Craig, on a Wednesday. Leave me be, y'all. Leave me to beaver. Leave me be. Good. Anyway. So the categorical absence of an overflow accommodation swept more broadly than required to protect any interest that the court identified. And the record does not reflect that the court considered any reasonable alternative, an overflow room with a closed circuit audio or video feed, a larger courtroom, or staggered or reserved public seating, as Presley required it to do, even on its own motion. The order's findings cannot bear the weight of the Sixth Amendment places on them. The court did recite findings that the case had generated substantial public and media attention, and that unrestricted access or activity may compromise the courtroom security, juror privacy, and the defendant's right to a fair trial. This was a fair trial? They made agreements from the beginning talking about they wasn't going to bring no character witnesses or nothing like that. That's why they weren't called. You know this, right? Who does that benefit? The state or the defense? Tell me who. You don't have to know law. You don't have to know legalese. You don't got to be Matlock, homie, to see the fixes in. You ain't got to be Matlock, bro. Nasty work, bro. But the findings of this kind are legally insufficient. They identify only generalized categories of concern, not the specific concrete facts or articulated threat that Waller and Presley require. And the word may confirms that the court identified a speculative possibility. May, not June, July. They might. Okay? Speculative possibility rather than a demonstrated risk. The Court of Criminal Appeals rejected materially similar findings in Stedman, where even detailed findings of the heightened security concern and potential juror discomfort were held as insufficient because they were generic and identified no specific threat or incident. In Stedman, the findings specific enough that a reviewing court can determine whether the closure ordered was properly entered and are the linchpin of the Waller test, which is the 4 factors that I told you of the Waller test, right? Let's go back to them. One factor, factor 1 of the Waller test. There must be an overriding interest that is likely to be harmed if the proceeding remains open. Ain't nothing happened at that court. Ain't nobody get hands and feet put on them. Even though a few people should have got some damn hands and feet put on them. There's being disgraceless out there. I ain't. They was acting like them people. All hell, little mustache guy. They was moving like that. I'm just saying my own feelings, bro. You can say what you want to say. I'm saying what I'm supposed to say. Whatever. 2, the closure must be no broader than necessary to protect that interest. 3, the judge must consider reasonable alternatives to closing the courtroom. And 4, the judge, this is the real one that you got to stick to. Yo, man, Karmelo was a king for, yo. Listen to the last one. The judge must make specific findings on the record. On the record, explaining why the closure is necessary. Did the judge do that? Hell to the no. Hell to the no. He didn't do it. Nasty work. Nasty work. Whew. And the generic findings will necessarily invalidate a closure. These findings are not only generic, they are unsupported because the court received no evidence. The court held no evidentiary hearings on the restrictions, took no testimony, and admitted no exhibit concerning a courtroom capacity, security, juror privacy, or the risks of prejudice. Findings on those subjects made without any evidentiary basis rest necessarily on either the court's own assumptions or on information outside the record, neither of which can satisfy the burden to justify a closure or support findings the defendant had no opportunity to contest. Stevie, he can hear that railroad more and more. Choo choo. Nasty. That distinction governs review. An appellate court defers to a trial court's finding of fact only insofar as they are supported by the record, and findings without evidentiary support receive no deference, nor may the deficiency be cured after the fact by post hoc assertions, and that the closures stand or falls on the findings that the court articulated when it acted. And the order's own recital that it affords reasonable public access consistent with constitutional requirements cannot be reconciled with its operative terms, a 10-minute entry window, no overflow, and no live streams, which demonstrate the opposite. The court's post-trial interview supplies no cure for these deficiencies. Check in the chat. Top posse. Drink your drink. So posse. Drink your drink. Yeah, so you know Uda from the town. Shout out to A-Dub in the building. Shout out to Grady. Queen Brielle still here. Hello Moto. William Denson, salute. Yeah, backdoor deals by the attorney is nasty work, bro. Nasty. It's nasty, bro. Yo, he was done as soon as he got there, bro. He was done before he even got there, bro. Straight. Luckily, he got some time outside. He got a bond, and he wasn't in jail the whole time before the trial came, because it was a railroad in the way. Straight, bro. It was most definitely a railroad on the way, bro. It's just nasty, bro. Absolutely nasty work. How long we have? Cool. Let's see what else. Where we at? Deficiency of the limited public access. That the rationale appears nowhere in the order. Contemporaneous findings and a closure cannot be rehabilitated by a justification offered only after the fact. The adequacy of a closure is measured by the findings the court articulated at the time, which must be specific enough that the reviewing court can determine whether the closure order was properly entered. Make sure everybody's slapping that like button. Make sure everybody's voting on that poll. Okay? When everybody hitting the like button and voting on that poll. Uda over here reading, homie. Okay? A lot of your people can't read. Let's keep it a fact. Uda taught himself to read. The reading rainbow, I can contemporaneously read anything. It's a fact. Let me show you a couple of my friends. They like this. My mama said, my mama said, don't flat to them. But Uda taught himself to do this. So make sure you supporting the stream. You know what I mean? Took that from Izzy Bands. Yo, make sure y'all supporting the stream. You know what I mean? Jack Izzy for the slogan. You know what I mean? Izzy, chill. Fall back, bro. Come on. Look. Let me see what the rationale failed by its own. Okay, wait. Let's start here by I. Let's take it from here. This seems interesting. The rationale fails on its own terms in any event. The Supreme Court has squarely held that even the compelling interest in protecting minor victims of sexual offenses are more sensitive concern than the mere presence of minor witnesses. I can see this though. I can see this reason of why they closing stuff. You know what I'm saying? Victim of minor of offenses that's sexual. Yeah, not just minor witnesses. Even though there were supposed to be some minor witnesses, I think. But everybody, I don't know. Other people testified. I don't know if some of them were minors or not. I mean, just because Karmelo and Austin and them, Austin would be 19 around his age, but just because Carmelo's 19, that don't mean everybody that's under the tent is the same age. Remember, you got other people that play on your football team, kids in 10th grade, kids maybe in 9th grade, on the track team, other kids as well. That's how come when the coach sent out the messages to Austin saying, listen, man, y'all need to step up. You and Rhett need to step up as well and be leaders on this team and be a good, you know what I mean, representation to the younger people that's on the team. Not be a leader and be Captain America. No, be a leader by your actions and show up. Don't celebrate yourself. You don't celebrate with the team. Celebrate with the team and everybody's accolades as well. You know what I'm saying? Celebrate them. That's what the coach was meaning by leading, not by you going to put hands on a person. No, by you being a leader, taking care of your responsibilities and doing what you need to do as a team player. Okay? Because if you set the motions out like this, that you doing anything that you want to do, what do you think the kids in the 10th grade is going to do? What do you think the guys in the 11th grade is going to do? What do you think the kids in the 9th grade is going to do? Because remember, you about to graduate from high school. So you're going to be off the team, but you've already set a culture of you getting away with things and them watching you get away with it. So they may try to do the same things. That's what young people do. We watch grown people doing that. See what I'm saying? So that's what the coach meant by him telling Austin to be a leader, not for him to be Superman and try to grab people and try to, you know what I mean? Go get a staff member, go get a teacher, go get an adult. And I wish that Austin did that, because if he did that, we wouldn't be here today. Regardless of what you want to say, Carmelo's this and Carmelo's that. If Austin did that, we would not be here today. We wouldn't even be talking about this. And it's sad. It's sad on both sides, bro. It really is to me. We just got to be honest with ourselves. Unless you don't have no humanity in you, It's a sad thing on both sides now. It's really sad. That does not justify a rule of mandatory closure. Protection of a minor instead rests on a case-by-case determination, supported by particularized findings that exclusion is necessary as to a specific witness. A generalized concern for minor witnesses could therefore support at most a narrow measure addressed to particular testimony, not a fixed seating cap, the elimination of an overflow room, and the denial of any live stream across this entire trial. Texas law confirms the point. Even in juvenile proceedings in which a child stands accused and faces adjudication of delinquent conduct, the court shall open hearings to the public unless the court, for good cause shown, determines that the public should be excluded, and only a child under the age of 14 must the court close the hearing. And then under the age of 14, but we know in Texas at 17, you're a kid outside of criminal activity. Okay. Maybe civilly, you're still a kid. But when it comes to criminal action, you're an adult. They're trying you as an adult. You're a grown person at 17 when it comes to criminal. When it comes to family court and family type situations, you're still a child still, in a way. You're still a child. But when you are criminally involved, you're an adult at 17 years old in Texas. Okay? At the age of 14, must court close the hearing, and then only unless the court finds that the interest of the child or the interest of a public would be better served by opening the hearing to the public. If Texas keeps open even the proceedings in which a minor is the respondent, the presence of a minor witness can't warrant the closing this adult criminal trial to the public as a whole. That's facts. Yo, mic drop. Mike dridded that dop. The mic twerking. That's how much the mic done dropped. Mike twerking, bro. Nasty. Nasty work, bro. Nasty work. That's part one that I'm watching, that y'all watching in the background. Part one to this read. That's what we're seeing on the screen right now. All right, cool. Let me read that again, bro, because that's crazy. That's nasty work. They said, if Texas keep open even in the proceedings in which a minor is the respondent, the presence of minor witnesses cannot warrant a closing that this adult criminal trial to the public as a whole. And finally, the order applied the wrong constitutional standard. It characterizes the restrictions as reasonable time, place, and manner restrictions. The standard that governs the regulation of speech in a public forum, that is not the standard for excluding the public from a criminal trial. Reasonable measures that merely administer the courtroom may be permissible, but the provisions that exclude the public, the 10-minute window, the space available, the seating behind the media cap, and which is the 9 seats, and the no re-entry rule, and the absence of any overflow rooms affect a closure governed by Waller and Press Enterprise, not by the more lenient time, place, manner test, but by treating an access closure as a time, place, manner regulation. The court applied a less demanding standard and bypassed the finders Waller's requires. Now, the orders. That way that boom box is going, that's somebody on a scooter. And preferably, ding, 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 ding. I'm not being racist. Ding, 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 ding. They Spanish, bro. Just leave it be, bro. They got the boom box like it's 1980. It is what it's going to be. They probably breakdancing outside somewhere. Anyway, the order's reliance on Shepard versus Maxwell does not assist Shepard's concerns a court's duty to control prejudicial publicity and press conduct to protect a fair trial. It does not authorize excluding the public from the courtroom. Now, a standing order is no substitute for an open courtroom, and every reasonable alternative was ignored. The form of the court's action independently offends the public trial guarantee. The restrictions were imposed not by case-specific evidence-based findings, but developed at a hearing, but by a preemptive written standing order. And the amended order regulating trial proceedings adopted in advance to govern all aspects of the trial proceedings. The Office of Court Administration in published guidance grounded in Waller and its Texas progeny, as has explained that no standing order or global rule for closure of specific categories of hearings may be preemptively issued by a court without running afoul of the requirement to provide the public with access to court proceedings. Now, because the court must instead consider all reasonable alternatives to closing the court proceedings and make findings in open court on the record adequate to support the closure, weighing the totality of the circumstances, the Office of the Court Administration Public Right to Access to Remote Hearings during C-19, the trial court is obligated to take every reasonable measure to accommodate public attendance at criminal trials, and the burden of doing so rests on the court. I wonder where that's at in this file, bro. Hold up, let me see something. But that's how I bring that back. That's cool. I want to see something. I'm on page 31, right? I'm on page 32, actually. Hold up. I'm on page 32. Let me just try to, I'm going to come back. Hold up. Let me see something. Let me see something real quick. Exhibit 4. Let me see something over here. Because somebody was telling me something about Exhibit 10. It's crazy. Hold up. Let me see if I could go through this. The clerk has Exhibit 4. Let me just see something real quick. Let me see. I'm on 32, right? Oh, I'll get back. Hold up. I just want to see. That's Exhibit 8 and 9. Wait a minute. Hold on. I want to know what's the big deal about Exhibit 10. What did Exhibit 10 say? Hold on. Yo, it's deep, bro. You gotta get through all of this, bro. You know how many pages it is? Nasty work, bro. Let me just skip through it real quick. Okay, wait a minute. Wait a minute. Oh, Exhibit 6. Oh, wait, hold on, wait. Hold up, what's this? What's this? Oh, Exhibit 8C. Let me just hold up, y'all. That's a lot of fluff, bro. I'm gonna get back to 32. Hold up. Let me see if I can find Exhibit 10 real quick. They told me something was going crazy on Exhibit 10 today. Hold up. This Exhibit 10, homie. Let's get to the fluff. Plant me, boy. Hold up. Affidavit of trial counsel Mike Howard. Wait a minute. What the hell going on? Let me read this real quick to y'all. So I ain't know what. Look, Mike Howard. Just so happened. I'm working on the railroad. That's how I work. Before me, the underdesigned notary public on this day personally appeared Mike Howard, who being by me duly sworn, deposed and stated as followed. I, Mike Howard, am at least 18 years of age, of sound mind, and I am competent and qualified to make this affidavit and have personal knowledge of the facts that stated herein, that they are true and correct. I declare that I was the trial counsel supported by second chair co-counsel Toby Shook, third chair co-counsel Tasha Gupta, and briefing appellate co-counsel Michael Mauler, who represented Karmelo Anthony in the cause number of, going to the cause number, leading up to the June 1st, 2026 trial of this case. And the defense and prosecution reached an agreement where the prosecution and defense jointly agreed to not raise any alleged character, reputation, or extraneous offenses, bad acts, evidences relating to Mr. Anthony, as well as Austin Metcalf and Hunter Metcalf during the trial, hereinafter referred to as the agreement. Bruh, you my homie, but you agreeing with the ops. Yo, bruh, if I was King Von and you was doing that, up room when Jesus comes. Are you on 64th Street talking to the ops talking about you making agreements, homie? You're not doing that because you know Vaughn didn't care. He had beef forever. How you doing that, bro? That's nasty work. Agreements. I've been telling you in this video that they've been making agreements, but now we see specifically. Nah, I'm glad I went to put page to exhibit 10. Nah, bro. I'm gonna read over these exhibits later on today and get y'all through the fluff. But we reading them saying the same shit about a bunch of shit. To hell with that. Let's get to the fucking the potatoes. I ain't gonna say the other thing because that's pause. But the potatoes. Look, the lead prosecutor in this case, Bill Werski, brought up the possibilities of the agreement a number of times well before the agreement was discussed in detail and eventually reached. When mentioning a proposed agreement, Mr. Werski proposed that we try the case clean. This was the weird thing that I read before, which he defined as based only on what happened under the tent that day. So what if those twins didn't like Karmelo from the beginning, had some bias towards him from the beginning, because we seen Eddie and him in the defense's photos. He was sitting next to him at a track meet, and Eddie played for their team. So what's the chances that they could have seen Karmelo too and known who he was too? He was playing on the football team, seemed like he was pretty good. He was playing, he was running on the track team, seemed like he was really fast and he was good at that. So what's to say that they didn't know him? They can even go into it. Your defense is making agreements already, bro. No, we don't want no agreements. Bring up his past and bring up your past. Let's go. Let's go. Because I guarantee you that them boys' past is more speckled than his past. Okay, cool. Nasty. Under the tent that day. Under the Memorial High School tent in the stadium on April 2nd, 2025. And not to go into character, reputation, or extraneous offense and or bad act evidence applicable to either Austin and Hunter Metcalf or Karmelo Anthony. On May 5th, 2026, Mr. Shook and Mr. Werski discussed this proposed agreement. I'm about to do my Stevie Wonder routine in one moment. Just wait. Agreement by phone. During that phone call, Mr. Shook and Mr. Werski discussed the evidence of character, reputation, and extraneous offense and bad conduct as it applied to both the Metcalf twins and Karmelo Anthony. Mr. Werski reiterated that he would be happy to try this without getting into character at all. Just on what happened today in the track meet. What is we doing? Yo, bruh. Nah. Who with me, bro? Who with me on this railroad, bro? Who's with me? Bruh, your defense making agreements with these people for what, bro? These people ain't your friends, homie. You from 63rd, they from 64th. You heard Vaughn. What's wrong with you, bro? We ain't friends, bro. We used to be friends when we was kids, but we ain't friends no more, bro. What happened to that? Nasty work. On May 8, 2026, the defense and the prosecution teams met in the Collin County grand jury room, and the prosecution team gave us a document entitled State's Notice of Intent to Use Extraneous Offenses. Hereinafter the state's notice, and we gave to them a document entitled Anthony's Motion in Limine. That's this word, limine. Okay. That's when they don't want you to say certain things in front of the jury. So they'll strike things, or they'll make a motion to say, oh, listen, man, I don't want the defense or whoever to say something that can contaminate the jury. So that's called limine, right? Boom. Regarding the admissibility of pertinent character trait evidence under the ambiguous aggressor rule. We got to go into that, bro. We got to go into that now. We got to break into that. What's that? What's the ambiguous aggressor rule? What's that? Scared of that. Scared of that. We getting on our Matlock shit now. Scared of that. I'm not playing none of these niggas. In plain English, y'all. Listen to me, y'all. You know, Uda gonna break this thing down for you. I'm gonna get you on your shots. Look, if evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted lawfully in self-defense. Let's read that again, bro. If the evidence doesn't clearly show who the initial aggressor was, the jury may be instructed to consider that uncertainty when deciding whether the defendant acted in a lawful self-defense. defense. It's not a standalone rule that automatically favors either side. Instead, it recognizes that when the identity of the first aggressor is genuinely in dispute, that the jury must evaluate all the evidence before deciding whether the self-defense applies. So a simple way for us to break it down is the ambiguous aggressor rule comes into play when the evidence doesn't clearly show who started the confrontation. So if the jury can't determine who was the first aggressor, which we know who the hell it was, the hell y'all blind? Don't let me go back into my Stevie routine. They had to carefully consider all the evidence in deciding whether the defendant was legally justified in using force. My Sherry Amore. My glasses out, man. My Sherry Amore. Stevie could see that railroad more and more. Jesus Christ. The evidence under text code, they break down the code. Hereinafter, the defense notice. After the tendering to each other our respective extraneous filings, briefings, we then discuss the proposed agreement, which Mr. Worski referred to as a gentleman's agreement. Gentleman's agreement? What do you think we doing here? Sipping tea? How many lumps you want, sir? Mr. Worski outlined the proposed agreement as follows. Both sides tried this case without character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. Who is this guy, Mr. Worski? Who's Mr. Maybe, yo, hold up, y'all. I have to do this. Who's him? Who is Mr. How you spell his name? Because he sounds like a straight op. Word ski. Man was a Viking in his past. Worski. Hold up. And Karmelo. Hold up, son. We gotta do this, bruh. We gotta do this so we break this down the right way. Who is he? Look at who's coming up with this deal. I already thought I knew who he was, but I just wanted to be factually correct. That's why I like to do facts. I don't do the guessing games around here. Okay, lady, you gonna beat with me or you ain't gonna beat me? You better get on your high heels and go. I ain't with it. I'm with the facts, lady. I ain't guessing games over here with me. See what I'm saying? So look, Bill Worski is the first assistant district attorney for Collin County, Texas. You don't say. Oh boy. And he serves as the lead prosecutor. Oh boy. In the Karmelo Anthony M trial, and he presented the state's case to the jury, handled witness examinations, and delivered the prosecution's argument, and later defended the verdict publicly after the trial. I ain't gonna do the Stevie routine yet. We're gonna save Stevie. My glasses is here. Anytime I do this, you already know. Stevie can hear it. He got supersonic hearing. But Stevie can also see the railroad. Oh, boy. Mr. Worski outlined the proposed agreement as follows, that both sides wouldn't go into without character, reputation, extraneous evidence for either the Metcalf twins or Karmelo Anthony, and just tried the case based on what happened under the tent. And during another description, during that meeting, what happened on the day of the incident, that benefits the prosecution and not the defense, bro. We need to go into what happened way before that. We need to see why he really had that weapon. All of these things matter before the day, but you only talking about what happens on the day, bro. You get what I'm saying to you? Shit. Seeking clarification, I asked, and Mr. Worski confirmed that this would mean that the defense would not go into evidence related to the Metcalf twin character. I'm gonna try to stop. I'm gonna try to just hold it together, bro. Yo, who with me, bro? Who with me for the railroad? On mommy. Yo, bro. You can't go into their behavior. How the hell you supposed to prove your self-defense until you go into their behavior and their character, bro? Cheerleader scared of them bugging. Please don't tell him it's me because I'm scared what they're gonna do to me. He said my hands is bisexual. Either boys and girls could get them. Even his own mama was scared of him, allegedly. And his pappy. I'm that damn dead pappy. And his pappy was scared of them boys. Don't do this. Don't let me bring up the documentations, bro. You know I'm with them facts. Lord Christ. Look, they would not go into evidence relating to the Metcalf twins' character, reputation, or extraneous offenses, acts related to violence and bullying, inclusive of discipline and write-ups in the Metcalf twins school records within this framework, as well as racism. Oh boy. In exchange, the prosecution would not go into the character, reputation, and extraneous offenses, acts, and evidence related to Karmelo Anthony, inclusive. Let's go. Karmelo wasn't doing none of that, what they was doing. Let's go. Let's try that one. Let's go. Try. Crazy, bro. That was a good thing for you to stand up and say, hell no with that, because they're going to lose that. They was bullies. They had the record of doing all of that. Karmelo wasn't like that, bro. He was done from the beginning, bro. This shows you the railroad right now, bro. I've been working on the railroad. Oh, in McKinney, Texas. Jesus Christ. In exchange, the prosecution wouldn't go into the character, reputation, and extraneous offenses, evidence related to Karmelo Anthony, inclusive of the contents of Karmelo Anthony's cell phone and school disciplinary records. Go into the records, man. Go into my phone, bro. Okay. At this meeting, I sought clarification on how this agreement would work practically, specifically how to handle the possibility of opening the door to this evidence from either side. During this meeting, Mr. Worski repeatedly expressed his concern that the defense would kick open its own door by asking questions of witnesses that would delve into issues restricted by the agreement. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident. Wait a minute. Let's go back. I asked about specific statements made by witnesses interviewed by police and captured by video on the day of the incident, where those witnesses discussed the Metcalf twins being passionate, triggered, and not tolerating being disrespected. Yo, bruh. Yo, son. Don't let me do it. Don't make me do it again, boy. He needed King Vaughn for a lawyer. RP King Vaughn, bro. He needed King Vaughn to be his lawyer, bro. King Vaughn wasn't going. He wasn't making no agreements with the ops. King Vaughn should have been his lawyer, bro. Nasty work. Look. Being passionate, triggered, and not tolerated being disrespected, etc. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific, listen to this. Mr. Worski eventually agreed that questions narrowly tailored to ask about specific statements that the witnesses made to police about the incident under the tent on April 2nd, 2025, including statements just described about the mindset and the actions of the parties involved in the incident, would not constitute kicking open your own door and thus would not violate our proposed agreement. During this meeting, we discussed the terms of the agreement, being that testimony from eyewitnesses from under Memorial Tent on April 2nd, 2025, and who were discussing the facts of what happened under the Memorial Tent on April 2nd, 2025 would be permissible, and that neither side would go into character, reputation, or extraneous evidence for either the Metcalf twins or Karmelo Anthony. During this meeting, I also asked about the agreement regarding the possibility of the defense calling experts. The prosecutor only discussed how the agreement would apply to the defense experts during the sentencing phase. So I asked how the possibility of the defense calling experts to testify during the guilt innocence phase would impact the proposed agreement. The prosecutor team replied that they had not considered us calling experts to testify during the guilt innocence phase. Who is with me, bro? Who's with me? Who's with me, bro? Who's with me? Sad. What's your name? Sad Bot. I don't know what's your name. Botita. I don't know what your name is. I don't know. You saying justice was served? This sounds like justice to you? I understand Austin was unalive. R.I.P. to Austin. I would never say he deserved to be out of here. I'm not that kind of guy. So I don't. They kids to me. They're children. Okay, and I think this went tragically wrong. But this sound like justice, or does this sound like a railroad? Sad Botita. If this was your kid, would you be happy that this is going down like this? You wouldn't be. I'm not onto nothing. I'm reading the case in front of you. What the fuck are you talking about? They're onto something, not me. Kick rocks. But anyway, have your own thought. This is not an echo chamber. Have your own opinion. So I'm not gonna stop you from having your own opinion. As long as we're respectful. Listen, they stated that if the defense called experts to testify regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate. They stated that if the defense called expert witnesses to testify in regarding Mr. Anthony's epilepsy or about the fight or flight response, they considered expert testimony like that to violate the agreement and thus the open door to character, reputation, and extraneous offenses act evidences. On May 11th, 2026, Mr. Worski, Dewey Mitchell, and Mr. Shook and I discussed the proposed agreement again by phone. I informed the prosecution that we had an informal agreement on a proposed agreement, but that we needed to have the final conversation with Mr. Anthony and his parents to confirm the final agreement. His family don't know law. They fools. During this phone conversation, Mr. Worski confirmed that the agreement would extend to the sentencing phase of the trial as well. And Mr. Worski said that would mean that in accordance with the agreement, the prosecution would quickly rest its sentencing case in chief without going into any of the allegations listed in the state's notice. Mr. Worski said, however, that he would not allow a false impression to be presented to the jury by a defense witness, and that if such a thing occurred, he would respond by going into character, reputation, and extraneous evidence from the state's notice. What, y'all was scared? Was the defense acting like they was shook? Toby shook? He was shook. Ain't no such things as halfway crooks. After the defense asked about an Anthony family member testifying at sentencing, Mr. Worski agreed that the agreement would cover Mr. Anthony's mother only, testifying to the standard, "I love my son, please show him mercy" type testimony only, but no further. Look at all the limitations on this case, bro. People don't even got room to talk, to say what they want to say, bro. On May 21, 2026, the defense and the prosecution teams met with Judge Roach in his chambers. During that meeting, both sides explained the agreement to the judge, describing it again as both sides agreeing not to go into character, reputation, or extraneous evidence as it applies to both sides during both guilt and innocence and the sentencing phases. As long as no doors are opened or false impressions are given, we agreed that that's the best way to document such an agreement would be for the defense to draft and file a motion in limine applying to character, reputation, and extraneous evidence applicable to all witnesses. So it would cover both the Metcalf twins and Mr. Anthony, but if made public, would not trigger reporting in the media about bad act evidence specific to certain witnesses, thus endangering a fair trial. On May 21st, 2026, I drafted the motion in limine as described above and sent it to Mr. Worski by email. It was hand delivered to the judge on the opening day of trial. The defense's understanding of this agreement: the defense understood that the agreement with the prosecution to cover all witnesses who could be called to testify by either the prosecution or the defense about the incident that occurred between Mr. Anthony and the Metcalf twins and their teammates under the memorial tent on April 2nd, 2025, as every description by Mr. Worski described the agreement to allow for testimony about what happened only under the tent. And Mr. Anthony was obviously a witness to what happened under the tent. By the plain meaning of the language Mr. Worski repeatedly used, the defense always understood the agreement to cover Mr. Anthony's potential testimony, just as it would any eyewitness to the incident. under the tent on April the 2nd, 2025. Following the plain meaning of Mr. Worski's words in describing the agreement, the defense understood that the agreement to cover testimonies by eyewitnesses, even the eyewitnesses, such as the memorial students underneath the tent at that time of the incident, Hunter Metcalf, and students outside of the memorial tent who looked over and witnessed the incident, and even Karmelo Anthony himself. This understanding of the agreement was further confirmed by events that occurred after the motion in limine memorializing the agreement. That's things that you don't want to say in front of the jury. That's why your striker make a motion. No, I don't want them to say this or something. I don't want the jury to hear that. That's limine. That's what limine means, right? So memorializing the agreement as was drafted and tendered to the prosecution on May 29, 2026. After a meeting with Judge Roach, the prosecution and the defense to discuss how the trial security will be handled. The parties discussed the timing of the state's case in chief and when the defense case in chief would start. Mr. Worski informed the court that that he estimated it would take 3 days for the state to present its case in chief, which would have ended sometimes on Saturday, June 6, 2026. In response, I voiced a concern to the judge in front of the prosecution team that some of the witnesses the defense anticipated calling to testify were unavailable on Saturday, June the 6th. So I explained that, like in any case, I would not know until the final moment whether we would call our client for sure. But that if the prosecution rested sometime on Saturday and the judge forced us to call witnesses immediately on Saturday, I may not have enough witnesses available to fill up a full day of testimony for Saturday. I explained that if this happened, it would force me to call my client out of order. The defense plan was to call all our fact witnesses first to establish certain facts and then to conclude by calling our client to testify as our last witness. So what happened? Yo, who's with me, bro? Slap that like button, bro. Slap that like button. Share this video, bro. Yo, bro. This is crazy, bro. It's absolutely crazy, bro. Can't with nobody say this is crazy, man. Hold up. My goodness, bro. Jesus Christ. On Friday, June the 5th, 2026, the second day of testimony during the state's case in chief, I checked in with Mr. Worski about how he was proceeding and whether he would end up taking more or less time to present his case in chief than he had initially estimated. Mr. Worski informed me that he was moving more quickly than he had initially estimated. So the prosecution was on track to rest his case in chief in midday Saturday. In this conversation with Mr. Worski, I again brought up the fact that several defense witnesses were unavailable on Saturday, and if the judge proceeded with his plan to force the defense to call witnesses immediately upon prosecution resting in order to have a full day of testimony on Saturday, we might be forced to call our client out of order. This time, I did not preface this statement with the perfunctory. Like in any case, I won't know if I am going to call my client at this time at last minute, but I was not on the record and I was speaking frankly with opposing counsel. I was very plain about the defense's intention to call Mr. Anthony to testify and how the judge's proposed schedule requirements were going to force us to call Mr. Anthony out of order. I don't independently recall what time on Friday, June the 5th, that this conversation with Mr. Worski occurred, but it must have occurred just before noon because I then sent an email to Michael Mauler describing the problem that we were facing and asking Mr. Mola to draft a brief for us to argue to the judge that he couldn't force us to call our client out of order. Throughout the morning and the early afternoon of Saturday, June 6th, Mr. Shook and I repeatedly checked in with Mr. Worski to get updated estimates of when he might rest his case in chief, each time referring to how the judge's plan was going to force us to call our client out of order. Besides the team repeatedly mentioning in front of Mr. Worski and the rest of the prosecution team that we intended to call our client to testify, even if it meant it would be out of order. Mr. Worski's own actions and arguments made it clear that he knew full well that we intended to call Mr. Anthony to testify, even before both sides tendered their notices of the arguments in favor of the admissibility of character, reputation, and extraneous evidence pertaining to the other side's witnesses. Mr. Worski made references to understand that the defense sought to introduce character and reputation evidence about Austin and Hunter Metcalf that was uncommunicated, unknown to Mr. Anthony via the ambiguous aggressor rule, which I just read to you from Torres versus the state. That's the case that it happened. Now, the ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in a case are all part of a self-defense argument. Let's read that again. The ambiguous aggressor rule and the admissibility of uncommunicated character and reputation evidence of the decedent in an M case are all part of self-defense arguments. Torres discussed in depth how the ambiguous aggressor rule allows the defense to put on an uncommunicated character and reputation evidence before and after the defendant testifies. So the Mr. Worski repeatedly brought up Torres in discussions with the defense team in months leading up to the trial, stating that while he thought the judge would rule correctly and not allow the evidence, he conceded that the character evidence could be allowed. And this repeated discussion of Torres and how it may apply to the trial showed that Mr. Worski was well aware of the least of the possibilities of Mr. Anthony testifying in order to argue his own self-defense. This was the entire entire purpose of the agreement, and that it provided value to the prosecution, limiting the defense from presenting damaging character and reputation evidence against Austin and Hunter Metcalf. This is what I've been saying the whole time, bro. It aided the prosecution. The defense is fools for this, bro. They fell for the trap, son. And the defense from the defense's perspective, the entire agreement centered around the defendant testifying without impeachment of character, reputation, or extraneous evidence in exchange for the defense not seeking to introduce character, reputation, or extraneous evidence against the Metcalf twins. Furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. Like all the other cases in Collin County that I was looking up, even the one white woman that unalived the black guy, her husband clapped him in the damn house, left him to perish right there on the bathroom floor. Then she blamed it on her two children. The kids was 2 and 6 years old. She said they the one that did it. Pulled that. Are you crazy? Left the kids in the house with the dead body. Okay, drove somewhere else. The police and responders came to the house, found the kids in the house with the body. They father. Look at the case. D-Ray Sims, D-E-R-A-Y Sims, S-I-M-S, Morgan Sims. She was the person. Guess how much time Morgan Sims got? After the prosecution was trying to get 25 years out of her. Guess what she got? She got 10 years probation. You wonder? Cool. Stevie ain't got to wonder. But do you wonder? What's your name again in my chat? Sad Botitiria. Who are you? What color are you? That's what I want to know. That's what I want to know, bro. Are you black? Then tell me. I doubt it. So, anyway. Again, furthermore, any competent criminal trial lawyer knows that for self-defense argument to have any chance of succeeding, the defendant must testify. For all these reasons, the defense always understood that the agreement to include Mr. Anthony's testimony free of impeachment by character, reputation, or extraneous offense or bad act evidence, just like every other witness, either side could call to testify about what happened under the tent that day. The defense's reliance on agreement. Throughout the trial, the defense revised its trial strategies in reliance upon the agreement. Absent to the agreement, The defense intended to cross-examine each memorial student witness that the prosecution called about Austin and Hunter Metcalf's character and reputation for violence, for being bullies, and for racism. The defense also intended to cross-examine these witnesses about various statements that they had made to the police on April 2nd, 2025, regarding Austin and Hunter being easily triggered, having a loud mouth, being passionate, and not allowing themselves to be disrespected. Some specific examples include, listen to this, Austin's a really big guy, and he's kind of like the aggressive guy on the team. Austin got the same way that he got during the altercation. Mhm. Austin got the same way that he got during the altercation is the same way that he got with some of us. And the mellow kid, something or whatever, and then Austin just kind of got triggered. Austin and Hunter, they're not going to let you disrespect them. And Austin, he's like a big guy, so nobody really wants to fight him. And Austin's really a passionate guy. And Jose told the police about Austin's history of fighting and almost getting kicked off the football team for fighting. I've known Austin for a while, and if Austin is about to get into a fight, you can tell. Austin can be a bit aggressive at times, and he has a bolder mouth sometimes. If the prosecution did not call any of these witnesses, the defense was ready to call them during the defense's case in chief and question them as hostile witnesses. Furthermore, the defense intended to call witnesses familiar with Austin and Hunter Metcalf's reputation for violence and bullying. And the defense intended to call witnesses who themselves were victims of the Metcalf twins, the violence and the bullying. The defense intended to question Memorial High School teachers about the Metcalf twins' disciplinary history contained in their school records, which corroborated their character for violence and bullying. And finally, the defense intended to elicit testimony about the Metcalf twins' arrest for racist graffiti. It was being racist to fucking Karmelo, bro. And he knew about their reputation too, bro. You never know about other schools from other kids from other schools that's bully or act like they this and this and that. You know about other kids from other schools. Even if you went to a certain school, you heard about certain kids. You playing on teams, you probably seen them do things. Other people that got bullied by them. You done heard people's stories about them. You think only a person in your school you're gonna know about when you're kids, when you're going to school? Think about when you were in school. Think about it. In good faith reliance upon the agreement, the defense did none of this. The defense even limited its questioning of witnesses about statements that they had made about the Metcalf twins being triggered, having loud mouths and being passionate, etc., that had been deemed to be allowed under the agreement in abundance of caution to avoid opening the door. Furthermore, because the prosecution had made it very clear that the defense calling any psychology-related expert would open that door to character, reputation, or extraneous evidence pertaining to Karmelo, the defense chose not to designate any experts and ultimately chose not to call as a witness a neuropsychologist to discuss how Mr. Anthony's epilepsy impacted his perception of the threat and the response. As that is relevant to self-defense as well, and a forensic psychologist to discuss both brain development of a 17-year-old as well as the fight or flight response as it applied to Mr. Anthony's character. As a result of this revision in the defense's strategy, the defense did not go into these subjects during voir dire or opening statements. That's why, man. Without such an agreement, or if the defense had suspected that the state would violate the agreement, the defense would have explored these subjects during voir dire and would have introduced these topics during its opening statements. In sentencing, in reliance upon the agreement, the defense did not designate an expert who was ready to testify regarding the mitigation, i.e., a risk assessment and psychological profile of Mr. Anthony. Furthermore, in reliance upon the agreement, the defense severely limited its available character witnesses to just 3 questions of Mr. Anthony's mother, which had been previously agreed upon. by the prosecution. Other than general character testimony and pleas for mercies in reliance upon the agreement, the defense also did not go into substantial family violence Mr. Anthony had witnessed and been a victim of in his home. Notification of breach of the agreement. On Saturday, June 6, 2026, the prosecution rested its case in chief and the defense called the witness Adam Linwood, Jeremiah Smith, and Jose Andre Ramos Moro, and before ending the day in the late afternoon, early evening. Now, on Monday, June 8, 2026, the defense resumed its case in chief, calling Brendan Steffens, called Brennan Lacey. The defense next planned witnesses, blank, had been avoiding the defense subpoena and kept changing the time he told us that he would arrive at the courthouse. Who is you, sucker MC? Sucker? Accordingly, after Mr. Lacey's testimony, we took a break at 10:50 a.m. to see if sucker MC, who's blank right here, had arrived. Damn sucker. He's a buster. Straight buster. During the 10:50 a.m. break in the back hallway outside of the judge's chambers, the judge asked us for an update about timing, how many more witnesses, etc. I explained that the next witness the defense had planned to call was a Centennial High School coach. Mr. Worski asked what the coach would testify to that did not pertain to Mr. Anthony's character. I explained that this coach had witnessed Mr. Anthony's seizures, so he would testify about Mr. Anthony's epilepsy based on his own personal knowledge. And Mr. Worski then argued that that testimony about epilepsy was irrelevant at guilt innocence, and to the extent it was relevant, would open the door to character reputation, extraneous evidence, and against Mr. Anthony. In plain terms, it would breach the agreement. I stated that I disagreed, explaining how it was relevant to Mr. Anthony's state of mind pertaining to self-defense, right? And that it did not relate. Yo, Shadow, where you at, Shadow? It's crazy, Shadow. And that it did not relate to the character reputation or extraneous evidence in any way. But Judge Rose agreed with Mr. Worski that he thought the testimony about epilepsy was not relevant during the guilt-innocent phase. These guys are friends. These guys are friends. How many of us have them? Friends. Ones you can depend on. Friends. And that it would open the door to character reputation and extraneous evidence based on this. I informed the court that I would not call the coach and that I anticipated having one or two more witnesses before I would call Mr. Anthony. In response to the judge's question about likelihood of Mr. Anthony testifying, I told the judge that we would need to confer with Mr. Anthony about his Fifth Amendment decision regarding testifying, but I was 99% sure that he would in fact testify. After the break, back in the court before the jury to give sucker MC more time to arrive at court, we then called Frisco Police Department Detective Riley to testify. After the Detective Riley finished testifying, I then decided not to call sucker MC as a witness, and we broke for lunch early around 11:17 a.m. And the prosecution and the defense team stayed behind to talk to the judge outside of the jury's presence. On the way back to chambers, Mr. Worski mentioned to Mr. Toby Shook that from his perspective, I had already opened the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony by saying that Mr. Anthony was a member of the chess club. What? During my opening statement, I did not say anything about a chess club at any time. During my opening, I said that Mr. Anthony played chess during my background description of him and his hobbies. Mr. Worski also stated that from his perspective, the agreement did not cover a testifying defendant. Here it goes. Here it goes. My Sherry Moore. Stevie Wonder could see the railroad more and more. I've been working on the railroad on the McKinney, Texas. From his perspective, the agreement did not cover a testifying defendant. Mr. Shook alerted me, and Mr. Worski and Mr. Mitchell and Mr. Shook and I stood in the well of the courtroom, and Mr. Worski repeated these statements, adding that the prosecution never thought that the defense would call Mr. Anthony. Why would you not think that? Did y'all just want to railroad him? You need to testify for yourself. Who else going to say that you defended yourself but you? You think people are going to speak about you when you think in self-defense? You need to go speak to your mindset. To testify, back in the judge's chambers, Mr. Worski repeated his assertion that the agreement between the prosecution and the defense never contemplated the testifying defendant. He elaborated, stating that he had never thought that we were calling Mr. Anthony as a witness, and he also repeated his claim that I had already violated the agreement during my opening statement by saying that Mr. Anthony was a member of the chess club. It is important to note that this was the first time that Mr. Worski mentioned that he believed that I had violated the agreement days earlier by mentioning that Mr. Anthony played chess during my opening statement. Although the prosecution and defense teams had conferred many times throughout the prosecution's case in chief about various issues, and this was the first time that Mr. Worski brought up this assertion. Judge Roach told us both, the prosecution and the defense teams, that my mentioning chess during the opening statement definitely did not open the door to character. So what the hell was Mr. Worski talking about? He's an op. Why are you making agreements with this man? Even the judge said, yo, bro, what you doing? That's too much, bro. That don't bring up nothing. But look how he digging. He playing psychological games. He's trying to get him not to say certain things and call certain witnesses and do certain things. Mr. Worski won this case, bro. The prosecution, bro. Tricked him, bro. You ever seen the Roadrunner? Yeah, bro. Coyote? Yeah, the defense was the Coyote, bro. He was the Roadrunner. He wins every episode. Yeah, it's a fact. It did not open the door to character, reputation, and extraneous evidence applicable to Mr. Anthony. The parties argued about whether the agreement between the parties covered Mr. Anthony's testifying. The prosecution repeated their position that it did not, and that if we called Mr. Anthony to testify, character, reputation, and extraneous evidence pertaining to Mr. Anthony were in play. Furthermore, Mr. Worski stated at the time that the prosecution, already having rested, character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. The prosecution already have rested. Character, reputation, and extraneous evidence pertaining to Austin and Hunter Metcalf was not relevant. When Mr. Shook and I mentioned the ambiguous aggressor rule from Torres, Mr. Worski argued that Torres did not apply because it was not ambiguous who the first aggressor was. Why not? The first aggressor was clearly Austin Metcalf. At this point, the discussion devolved into a shouting match. That's what they was doing, son. Prosecution did what they were supposed to do, bro. Even if we think it's foul, they did what they supposed to do, bro. Why the defense wasn't doing what they supposed to do? That's my question. Answer it in the chat if you want to. Answer it when you see this video on replay. The impact on the defense's case. After the breakdown of the agreement, the defense and the prosecution teams agreed to take 10 minutes off to cool off before attempting to renegotiate parameters for how the agreement could extend to Mr. Anthony's testimony. Should the defense now choose to call him after the 10-minute cooling off period, Mr. Worski and I met in open court outside of the presence of the jury and without the public in the room to discuss the possible parameters for the agreement covering Mr. Anthony's testimony. Given Mr. Worski's expansive view of what he considered would be the open door to character, reputation, and extraneous evidence pertaining to Mr. Anthony, especially his repeated claim after the judge stated otherwise, that it wasn't open the door, that even my mention of playing chess opened the door to character, I resolved that my only choice was to go over my planned outline of Mr. Anthony's direct examination line by line. Why are you going over this line by line? You're supposed to be able to pull something out. So they need to prepare and get their mind right so they could combat it. We're playing chess here, live. This is a match, a back and forth, a tug of war is a court case, bro. They privy to all of this, so they already know how to prepare for you. line by line with Mr. Worski to determine what would and not be in Mr. Worski's view the open door. This is how he got him to explain all the little secrets that he thought he wanted to try to help his case, to help his client in the case, bro. Do this full Mike Howard understand this? Who is Toby Shook? Is he friends with these guys? I've never taken such a drastic step of previewing my strategy and even my questions with a prosecutor. Listen to what he just said. I have never taken such steps, drastic steps, of previewing my strategy and even my questions with the prosecutor. It's a tug of war. You're about to prepare for what you're about to say. How are you supposed to win, sir? I'm not a lawyer and I know this. Yo, I stopped smoking trees, man. I might have to smoke a bleezy after this one, bro. It's facts of life. I'm going to get me a split. Truthfully, kids, don't do it. But I think I'm gonna take me a pull of some Bob Marley today. It's over. Listen. But as a defense team, we agreed that we had no other option if we wanted to try to reach an agreed understanding with Mr. Worski of how the renegotiated argument would cover Mr. Anthony's testimony. As I went through my outline with Mr. Worski, what line by line, giving up your whole defense strategy, standing reading the outline over my shoulder, Mr. Worski declared various subjects that, in his view, would open the door to character, reputation, and extraneous evidence pertaining to Mr. Anthony during this discussion. Mr. Worski repeated his claim that my earlier mention of chess opened the door. While I disagreed with all of Mr. Worski's assertions of subjects that would open the door, I agreed to cut them from my questioning in the hopes of salvaging the agreement to keep Mr. Anthony's extraneous offenses out if he testified. What are those offenses? Let us know. What did he do? He got something that he wants to hide from Karmelo's background. So is Karmelo Anthony's background as clean as we think it is? Why is he trying to hold on to this agreement to hide that? You have to think of both sides, not just the twins. I'm thinking of Karmelo too. Why is his defense team doing this? What did he do? What did he do in his past? At the end of this discussion, with the understanding that Mr. Worski would extend me leeway to lead Mr. Anthony more than normal through certain aspects of the testimony, in abundance of caution to avoid opening the door, Mr. Worski and I informed Judge Roach that we had come to an agreement as to how the renegotiated agreement would cover Mr. Anthony's testimony. We then summarized the process, and we had just gone through our renegotiated agreement on a record. Now, prior to breaking to allow the defense to retire to the defense room to discuss the issue with Mr. Anthony and his parents, Judge Roach informed us that he was aware of no mechanism at his disposal to enforce the agreement between the parties. Furthermore, Judge Roach informed us that he couldn't even enforce the agreement, bro. You could have been broke that agreement. To hell with y'all. I'm doing my own thing. G-Unit. I started my own gang. G-Unit. Doing my own thing. To hell with you. You should have just got the leg up and just broke it. Whatever, man. Bring what you want to bring up. So y'all already rested y'all case. Break the agreement. See what I'm saying? Judge couldn't even enforce it. That's how you pull the rug back from under somebody that pulled the rug from under you. Break it. Hell with you. Judge can't inform it. I mean, can't stamp it. Furthermore, Judge Roach informed us that he saw no way for Mr. Anthony to testify without the door being opened. For example, if he said that he bought the knife by accident or said that he was scared, etc., this would almost certainly open the door. Look how they trapped him. To character, reputation, and extraneous evidence of some sort. To clarify the issue, I propose the hypothetical scenario that if Mr. Worski claimed that the agreement had been breached in some way, and if I and even the judge felt that Mr. Worski was operating in bad faith, that the judge was stating that he could not enforce the agreement. would have to make the ruling based on the Texas rules of evidence alone, and that, in all likelihood, the door would have been opened. Judge Roach confirmed that this was the case. When we then broke to discuss the issue with our client, Judge Roach gave us approximately 10 minutes to explain all of this to a 19-year-old kid who don't know nothing about law, who don't know nothing about the situation that he's really in. All he knows is what happened under that tent. 10 minutes to explain the breakdown of the agreement and the proposed resolution with our client before the judge brought Mr. Anthony in for on the record admonishment. Bro, he didn't even know about this agreement. They breaking down this agreement now to him in 10 minutes. Did you really break this down to the parents and say, this is what this agreement's going to be about? Did they go get other attorney, go get other help, use Chat GPT, AI to ask, would this help you? Write down the whole agreement. Let me read it to Chat GPT. My son is in here for an M charge. This is the agreement that they're making. Is this going to benefit the defense or is this going to benefit the prosecution? Chat GPT tell you right now, to hell's no. That's all. There's 3 words. To hell's no. That's what ChatGPT gonna tell you. Not no big paragraph. To hell's no. Shit got me tight. This part right here got me tight, bro. Straight up. I told you somebody told me read 10. Exhibit 10, bro. Most passion I got out this whole reading, bro. Yo, during the initial pre-admonishment meeting with Mr. Anthony and his parents, I did my best to explain everything that just happened with the help of Mr. Shook and Mrs. Gupta. We then returned to the courtroom for the Judge Roach to admonish Mr. Anthony about his Fifth Amendment rights and also to explain that if he testifies, Judge Roach believed that he had no mechanism to enforce the agreement between the parties and would rule on the rules of evidence alone as to whether the door had been opened. Judge Roach gave us 10 minutes to discuss his Fifth Amendment rights with Mr. Anthony and help him ultimately decide whether he would testify or not. Told you, bro. I told y'all this. I just told y'all this in the beginning of this video. I asked for additional time. I told you this too. I asked for additional time to have such a complicated discussion with a 19-year-old in the most stressful situation of his life, but Judge Roach declined to extend our time beyond 10 minutes. Again, we did our best to explain everything, the pros and the cons of testifying versus not testifying, the likelihood of winning on self-defense if he testified versus if he did not, the likelihood of whether we would get instructions in a jury charge on the lesser included charges of manslaughter and criminally negligent homicide if he did. And if he did not testify, and the likelihood of whether we could get instructions in the sentencing jury charge if we got there on sudden passion, if he did and if he did not testify. During this discussion, beyond all above, the most complicating factors of all was whether Mr. Worski would claim that we had opened the door. Look what they're thinking about still. And then bring in Mr. Anthony's extraneous offenses or bad acts. What are these acts? What are these offenses? Character and reputation based on his actions and claims, specifically his repeated assertions, even after the judge had firmly disagreed that I had opened the door by even mentioning chess, as well as a general claim that the agreement had never contemplated Mr. Anthony testifying. Despite the plain meaning of the word Mr. Worski himself repeatedly used to describe the agreement, bro, he's a prosecutor, bro. He knows for you to really prove self-defense, you need to testify in your own defense, bro. You need to testify in your own defense to prove self-defense, bro. He knows this as a prosecutor, bro. How many trials has Mr. Worski served? Man has got to be in his 50s or 60s, probably his 50s. How long has the man been a lawyer before he became a prosecutor, bro? He don't know that? They said any lawyer, bro, a lame lawyer knows this. You need to do these things to prove self-defense, bro. I read that to you earlier. Okay, this was amplified by the fact the defense team felt strongly that the risk of Mr. Worski claiming that we opened the door was too high. So this was amplified by the fact that Judge Roach made it clear that that should Mr. Worski claim a breach of the agreement, he felt that he was unable to enforce it, and that in all likelihood, the door would have been open at the end of the 10 minutes. Despite our request for additional time, Judge Roach called us back into the courtroom to announce Mr. Anthony's decisions and proceed with the trial. Ultimately, Mr. Anthony chose not to testify. This 180-degree change in the defense strategy was the direct consequence of the breach of the agreement. The breach of the agreement affected all aspects of the defense's case. By that time, the agreement was breached, and it was too late to change our approach in voir dire in the opening, too late to ask different questions of the prosecution's witnesses, and too risky to recall those witnesses. To ask questions that would risk the prosecution deciding that we had opened the door greatly hampered our strategy during the sentencing, causing us to decide not to call witnesses we otherwise would have called, and severely limiting the questions we asked of the one witness we did in fact call, and the prosecution's breach of the agreement directly and significantly undermined the defense's ability to present a complete case, bro. Signed and sealed, Mr. Mike Howard, bro. Damn. That's crazy, bro. Yo, bro, that's crazy, bro. That's crazy, yo. That's crazy, man. Whether you wanted Carmelo to be in there frying, whatever you want, bro, whatever you think, bro. You know what I'm saying? I ain't a lawyer, bro. I ain't tried this case, bro. I ain't tried this case, bro. But what I just read to you, bro, is a setup, son. And you mean to tell me what Mike Howard is just foolish enough to do this thing? I was saying from the beginning, remember, I read about some of those things in the beginning. I'm like, they came to agreements. I'm like, what? We only going to talk about everything under the tent. That's it. What? Bro, that only benefits the prosecution. That benefits the state. That doesn't benefit the defendant, bro. I knew this from the beginning. I've been telling you on my last video, I said this. I didn't even get to Exhibit 10. That's crazy, bro. You mean to tell me he didn't plan and the agreement didn't entail his own defendant testifying? What the hell are you talking about? What kind of cases was he trying in his life? I'm going to go through Mr. Worski's whole life and every case he ever tried. And if anybody ever claimed self-defense in a case that he had, and if they ever testified, bro, and how many cases? I had 10 cases where a person pledged self-defense out of 100, and all 10 of them testified. So yet he don't think that Karmelo supposed to testify? Bro, this is how I go to breaking shit down, son. I go to cases, bro. I'm not with the fluff. I'm not with the bumping of my gums, bro. See what I'm saying? R.I.P. to Austin Metcalf, but I'm telling you the truth, son. They were seen like bullies. Even their own students, even them witnesses that was in there was saying that. Even the own witnesses was saying that. Besides that cheerleader that was saying things about them too, bro. They got a history of being bullies. And he's so goddamn big, nobody wants to fight him. He's 6 foot and 200-something goddamn pounds. He's running around like goddamn Randy fucking like Rampage in UFC. Yo, this is nasty, bro. This is nasty, bro. Salute to everybody that rocked out. What in the world could they have with a 17-year-old boy that was so bad to not risk testifying? That's what happened, bro. That's what happened. It wasn't not risk it. Everything that they wanted to do, they had this fake ass agreement that they agreed to, which they should have never agreed to. Should have just went into it, bro. Bring up his character. Bring up extraneous evidence. Bring it up, bro. Just bring it. Bring it. Because when we go into the twins, it's still going to trump his. When you go into the twins' background, it's still going to trump his background, bro. Who's testifying that Karmelo was bullies and all of that? His own friends, Austin's own friends is testifying. Cheerleaders on his team is testifying that they like that. They're aggressive. They can be rough. They can be all these things. Who's going to say that for Karmelo? Remember, he was from a whole other state. All they know from him is being a good boy. Besides maybe the 1 or 2 incidents that he probably went through. Who's going to testify to that? They're going to go into his cell phone records. Maybe he was saying things in his cell phone. You know, you start talking on phones, you texting people. Keep your phone, get a new phone. You keep your phone, don't turn it off. You leave your phone on. You get a whole new phone, prepaid joint that you're using. Get a whole new line. You use that phone. You keep your phone line on. Here, take my phone. I ain't said shit on that. I ain't never said shit. Y'all never gonna see my next phone though. See what I'm saying? Chill, bro. Salute to all of y'all, man. Hopefully y'all drop likes. I know y'all did it. I know y'all ain't hit the poll like that. I already know y'all didn't, man. You know what I mean? Salute Drip. Salute to you, bro. You know the vibe. I know y'all didn't. You know, I don't be asking y'all for too much, bro. I don't be here begging y'all for nothing. But yeah, they railroaded them, Drip. You know the vibes, Drip. Yeah, they railroaded them, bro. Stevie Wonder on the way out. My cherry more. Stevie Wonder can see the railroads more and more. I've been working on the railroad in McKinney, Texas. Whole damn railroad, bro. Whole damn railroad. They agreed to that fake ass agreement that didn't benefit nobody but the prosecution, bro. Nobody but the prosecution, Drip. Nasty work. My man, the plug I'm talking to right now in the chat. My man, him. He hollering them with the railroads and Stevie Wonder. Nasty work, Drip. Nasty work, bro. Yeah, bro. I'm gonna read more of this case in a minute, bro. I need a break some from reading this shit, bro. This shit just had me hot. This shit is just crazy, bro. You know what I mean? And I've been trying to be balanced on both sides and just kind of, you know what I mean, give up the story the way you're giving it up. Even though I know what I feel about and see certain things in this thing. I already see the railroads. You know what I'm saying? You know what I mean? Stevie could see it. So he got supersonic hearing, but his ass could see it too. It's nasty, bro. It's just nasty work, bro. Straight, bro. Hey, OG Patrice. Hey, OG Patrice. You know I love you, Queen. Bless you, man. Always a blessing to see you, man. Been a long time, OG Patrice. Oh, it's been a long time, Queen. Shout out to you, man. Hopefully everything is well with you and your family and everybody, you know. Beginning of times, man. And you've always been a good soul to me. So I appreciate you always. Just know that. You know. I was thinking about bro Clarence, man. I think I'm gonna. We'll talk. We'll talk. You know, we'll talk. Shout out to you, man. Shout out to everybody that just passed through this, man. Hopefully y'all liking and sharing. Hype the video, you know what I mean? Yeah, man. Just reading that just got me really deflated, dejected, all kind of words with D's, pause, defense. Yeah, that's what this shit did to me, bro. Nasty work. Always. Salute to you, Queen. Yeah, man. You already know, man. Make sure you subscribe to Udo and go hit the notification bells and make sure that you're notified when we drop a new content, man. Udo. On feet. Never Ricky out the car, stupid. On go. That's my name in sign language if your ass can't speak. Tap, tap, tap goes the weasel. Okay? Tap, tap, tap. Tired of this shit. This shit got me tight.
All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been as right. All my niggas turn shooters. All my ops turn racks. All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been as right. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All my niggas from the Uda. All my niggas turn shooters. All my ops turn racks. All my niggas turn shooters. On the internet, you ain't been a threat. You been stuck in a computer. Show me the proof. All my niggas turn shooters. All my niggas from the Uda. Welcome to the Uda. All of my niggas insane. They tryna catch a mistake. Young niggas putting in pain. It in the game, all for the game. Niggas ain't playing for nothing. Went in school, laying it bang. My little nigga kill my little nigga. Full-time job not to kill niggas. Jump off the porch of the field, nigga. You was in the house, I'm a field nigga. No fuck boys around real niggas. Been a drug dealer since a little nigga, huh? Taking a kilo, they'll kill a nigga. Fuck how you feel, nigga. To get some kilos, I'll kill a nigga too. Throw that rock like I'm Montana. Good head, raise my antennas. G49, not San Fran. Beat the box with my bandana. Then I dip set like I'm Santana. I'm in UK like that Montana. She bring me money, you press her. You got a jug and finesse her. I give a dick that'll change her life. You leave her change on the dresser. Shorty a wetty. That pussy ready, get ready. Don't wanna get ahead of myself, but I want the head for the Getty. She said